Maddie has begun the recording. Okay, it is 1 p.m. on October 20th, 2025. I almost said 1925. This is a meeting of the Land Use Review Board. I am Janet Hurley, the chair, and I will ask board members to introduce themselves. Sarah?
Sarah Hyde, good afternoon.
Alex?
Alex Weinhagen, hello.
Brooke?
Brooke Dingeldine, good afternoon.
And Kirsten?
Kirsten Sultan.
Thank you. That is all 5 of us present. Are there any agenda updates from board members? I see none. All right. Opportunity for public comments on non-agenda items. Oh, Kirsten.
Can we back up a moment?
Yes.
I believe that during item H that we will be discussing a personnel issue. So I would like to make a motion to add that to item H of the agenda.
Yes, thank you. I forgot that. Thank you. Any discussion on that? Okay, all those in favor, please say aye. Aye.
Aye.
Aye. Aye.
Aye.
That is unanimous. So we will add personnel to our executive session motion and discussion. Okay, so opportunity for public comments on non-agenda items. Thomas is shaking his head, and he's the only public here today so far. So I think we can move on to our consent agenda. Review and approval of October 6th and 9th minutes.
Yeah, I'll move to approve both pursuant to whatever revisions we discuss in a moment.
Great, thank you. Alex?
A second.
Thank you, Kirsten. Okay, let's start with October 6th. Any changes or revisions for those minutes? No. I see shaking heads. All right, October 9th. Let's see, Brooke.
Yeah, I didn't get my own summary in there, and I thought it would be prudent to add the following. I didn't realize it was not incorporated. So I'll read it to you unless you want me to put it on screen. It's just a couple sentences.
You can go ahead. Yeah.
Okay, because I wanted to add, the discussion also covered procedural aspects of the proposed board model, particularly discovery and motion practice. Dingeldine highlighted the desire to save time as well as the challenges in curtailing these processes, referencing the Public Utility Commission's practices as a model. The role of a case manager was proposed, ideally a board member, to oversee case scheduling and management, with legal counsel assisting in legal motions and decisions. Board members agreed with this proposed approach.
And that would be right before item G on page 6, correct?
It would be the second paragraph added to the existing one under the appeals study.
Right. Okay. And then I had proposed some clarifications on Thomas's public comment. And I see nodding heads. Any other revisions for the October 9th minutes? Okay, so we have a motion to approve both sets of minutes with those revisions. Any further discussion from anybody? No. All those in favor, please say aye. Aye.
Aye.
Aye.
And that is unanimous. Thank you. Those minutes are approved. Next on the agenda is operations, budget, and legislative updates. And Sarah will lead us into a discussion on budget. When we submitted the budget to Finance and Management, we got a request from them to perform a certain exercise, and Sarah will explain what that is about and our thinking on that.
Well, I'm going to have Rachel help me explain it a bit, but the upshot of it, I think, is that we have to do an exercise that we will show how we could cut if we were going to cut. And we can also balance that out with revenue. And I think what I'd like to propose is, because we were so conservative on revenue, because the anticipation that we could have tier ones ready to go for next fiscal year, but that does not appear to be the case right now. I think it's going to be much slower of a process. So we were so conservative with the special revenue that I think we can increase that to do an offset and increase that back up to mid-range to 1.54 as opposed to, I think we were at the very low end of the range. And historically that's been more up by 1.8, 1.9. So I feel comfortable making that recommendation for the exercise. But I think Rachel can, if people want, explain a little bit more about why we have to go through this exercise, what the exercise is, and that we aren't necessarily cutting right now. It's that we have to propose that if we didn't get what we wanted for a budget, how we would try and address it.
I think you summarized it pretty well, Sarah, but just to go back maybe a couple steps. Our original budget submission for fiscal year 27 was entered last week, October 14th. We had projected a general fund increase of about 6.8% general fund increase over fiscal year 26 levels. The request from Finance and Management is to understand how we might how the land use review board might prioritize getting to a 3% general fund increase rather than the 6.8% that we proposed. This isn't something, it's an exercise. It's not something that will totally come to pass, but it may come to pass. And there are really two ways to go about tackling this exercise. The first is cutting costs out of our budget. The second is reallocating costs, between, rather than having an increase in our general fund, accommodating that increase in our special fund related to feed revenues. And I will just remind folks that as a part of this budget process, we had a small group that kind of looked into all of these parts and pieces over time. One component of that was looking at the last 3 fiscal years worth of special fund revenue information and modeling what tier 1A exemptions how those might impact our historic fee revenue forecast. So that presented us with a range of special fund revenue. The committee decided to, take a conservative stance on that and position our special fund revenue towards the lower end of that bracketed range. But it is also that analysis really took into account if every tier 1A area was approved as a tier 1A area in fiscal year 27. It was a very conservative analysis, and we also took the step of being conservatively skewing towards the low end of fee revenue in that analysis. So I do think there is a case here to accommodate this exercise by increasing our special fund revenue forecast for fiscal year 27. Currently, it's at 1.3. We would be increasing it to 1.5 to accommodate the additional 3.8% change between general fund and special fund. So I'm going to stop there and then take questions from the board on approach.
Just clarification, I think it would be 1.54, right? Rachel?
Yes.
Okay. Any questions from board members? Alex?
Rachel, can you talk to us about what it was last year and how 1.54 compares?
Yeah, so for fiscal year 25, we did $2.38 million in fees. I think accounting for all of the tier 1A areas, applications that might be now exempt, given where tier 1A may come into play. The revenue projected for last year is 1.94. It's about
All right, Rachel.
$425,000 to $450,000 that we would lose year over year in tier 1A estimates in a worst case scenario.
So just to clarify, in FY 25, which is the year we have actuals for, we took in 2.38 million in special revenues, and projected for the fiscal year that we're in right now, FY 26, it's 1.98. Is that right?
Well, if you were to take that fiscal year 25 and say, let's subtract away potential tier 1A areas from it, I think it would be $1.94 million would have been our actuals in fiscal year 25, kind of in this projection analysis. Do you see what I'm saying?
Now I understand. Yes.
What we proposed in our original budget submission was $1.38 million. What I'm proposing to go to is $1.54 million. And that is well under what our actuals would have been last year.
Gotcha.
Accounting for tier 1A. Do you know what I mean?
Gotcha.
Okay.
Yeah, that makes sense to me. Where are we to date though with this fiscal year?
Yeah, I just looked at that this morning. I think we're just over 650,000 in actuals year to date. Obviously, the year starting July 1, 2025.
Okay.
So thinking about this in fiscal year, yeah.
You're not foreseeing that this fiscal year is going to be an anomaly in terms of the special revenue as far as 650,000 to date.
I don't think so, but
Yeah.
This is all there's a lot of other factors at play that can impact what somebody might want to move forward with a project or not, right?
Right.
There's lots of different variables in that equation, and I can't be sure about all of them. So
I'm asking because there's a couple ways to set projected revenue for the future, right? And one way is to look at the past and just say it's going to be the same or a little less if we have some tier 1A or tier 1 areas that are exempt. And another way is to say, well, we know where we are in the current fiscal year, and we're seeing some of the impacts, and we have a crystal ball, and we're gonna make projections that are different from the past. So yeah, that all of that helps. Thanks. And I guess my last question was, you said when we set the original budget with special funds revenue anticipation for FY 27 of 1.3, is it 1.37 or
I think
Oh, 8.
yeah.
Yeah.
You said that there was a range of revenue reduction due to the tier one exemptions. And and this budget, used the upper end of that, the most conservative. So what was that range? Or did you already say it and I missed it?
Yeah, I think that we've covered that in a previous meeting, but over the, if I'm looking back in time through fiscal year 25, 24, and 23, right, where we have actual revenue. And I'm looking back at those projects and seeing which of those projects would be considered a tier 1A area if tier 1A areas existed, in that framework. So the range there would be, just give me a second. Fiscal year 25, at the higher end of the range, 1.94. And fiscal year 24, at the lower end of the range, 1.22. So
Okay, what about fiscal year 25 low to high range? You said the upper end of the range was 1.94.
no,
That's,
I'm talking about ranges over different fiscal years, not ranges within fiscal years.
Okay, sorry. I was under the impression that you had a range within a fiscal year of like, could be this much to this much. You just took all of the revenue that could have come from a tier one community and accounted for it. You didn't look to say, well, we'll take 50% of that. You just gave a number for the whole thing.
Yeah,
right,
I
for
think that
each of
was a
those 3 fiscal
conservative.
years. Yeah,
We did that to have the analysis be a conservative analysis.
Brooke?
But it was data driven is what you're saying. You looked at the history of the existing permits and determined in some methodology what percentage of them or which ones would be exempt, therefore, we wouldn't be getting the revenue from, right?
Yeah, I mean, specifically, we've looked at the, geographic distribution of these applications, and if there was a regional plan application that was published online, and we looked at what would be, those future land use areas, what would have fallen within them geographically, and did the analysis in that way. If there wasn't something published online, then we looked to the designated downtown areas to kind of approximate the analysis as best as we could. But it was a geographic, data-driven analysis. And Janet and Sarah both were part of that, kind of talking with communities and different municipalities around who might be interested in applying for a tier 1A area, to understand what community should we actually look at in that geographic analysis.
I think that's great. That's the best that we can do. And kudos for the approach, because so many unknowns, we have to at least tie this to whatever we can on the ground. So thank you.
Sarah?
I was gonna say, not that I want to get too far into the specifics on this, because I think we promised some anonymity to regional planning commissions in terms of when they gave us their potential list of who might want to become tier 1A, but we've forecasted for everybody sort of coming in all at once and becoming a tier 1A and excluding, and what that would look like. Since that time, I've heard from some communities that were on the fence that we included that will not be. So I feel, and then also in terms of timing, this is going to take multiple years to get through. So I feel fairly confident that we did a revenue forecast for a worst case scenario, and we can back off of that a little bit now, I think, with some of the additional information that we've had and some more specifics.
So that was my question. What explanation will be provided? Is it only, oh, well, we're no longer going to be as conservative, or it sounds like we do now have more refined information about the specific municipalities that we interpret may or may not be pursuing tier 1A status. I feel like that should be incorporated into the response, if assuming there's some kind of narrative that goes with it. But thank you.
And yes, Kirsten, I think that would be the approach. Alex.
Rachel, so I'm trying to get the basic numbers, which I think you maybe already gave us, and I apologize if I'm not looking back at the right document for actual special fund revenue. And we just talked about FY25. That's the last year we have, the most recent year we have available for actual revenue. You mentioned FY24, but just with the tier 1A, extracted from it sort of example. What has been the trajectory of our special fund revenue over, say, the last three, not last three, but the last 3 fiscal years that we have actual data for? Because if it was 2.38 million in FY25, I'm just curious how that's tracking with regard to the interim exemptions and such.
I don't think that our special fund revenue doesn't have a consistent trajectory. That is predominantly because we cannot solicit, we're not soliciting applications, right? It's whatever applications are coming about through other mechanisms, it can be largely tied to how the confidence of the development sector, right? Which may be tied to interest rates or other things that can fluctuate from year to year. I feel like we only looked back at the last 3 fiscal years because those are somewhat more predictable years than COVID years, right? There was some pretty wide-ranging results based on predominantly interest rates and the ability for people to actually build a project, right? So it can swing between fiscal years. And so fiscal year 24 and fiscal year 25 kind of show that inherent swing in revenue forecast. That's why we were talking about looking at a bracketed range, a conservative estimate, and trying to, our first go around with this budget submission being kind of skewed towards the conservative side of that equation. So it feels like this fiscal year, we're on track so far, but there's a lot of things, in the macroeconomic picture of our state and our country that could throw a wrench in things. And that's why budgeting is an estimate.
Yeah, I get it. And I've done budgeting at a much more micro scale at a municipal level with the same kinds of things in mind. So I'll just ask you a specific question. And if you have the number in front of you, what was the actual special fund revenue for FY24?
1.69.
Okay, so 1.69 in FY24, it went up to 2.38 in FY25.
You want the actuals for FY23?
No, I understand the COVID problem, so FY24 is helpful.
Yeah.
And and our estimate for this year for FY26?
What we are estimating is in our budget.
Yeah, I'm just hoping you know.
1.36 is what we estimated this year in our budget. Again, that was an analysis that we did last year at this time, not really knowing how any of the board's work was going to progress, on what timeline it would progress on, and the details of that progression. So I think that we potentially overestimated the fee revenue impact of some of the board's work last year, which puts us in a position this year to, like Sarah said, take a back off that conservative stance. And I do think that there's a data-driven analysis that supports that we can talk about with finance and management. And also, like Sarah said, we assumed a certain set of municipalities were gonna apply for this tier 1A area status, that those assumptions may not, there may be less municipalities that actually take that approach. So collectively.
So the part of why I was asking for the other numbers is I think that the response we give with regard to this data-driven analysis and change to the revenue forecasting is twofold. Only one side of that coin is our revised projections about tier 1A areas. The other side of that coin is an acknowledgement that we underestimated revenue for FY26. If we estimated 1.36 million and we're at half of that or nearly half of that right now, and we're not halfway through the year, then we're going to bring in more revenue, most likely in FY26 than we anticipated. And I would like to highlight that for finance and budget, tell them like there's a couple reasons why the way we chose to complete the exercise was on the revenue side. And, tier 1 anticipation is one reason, and the realities of our under projection of revenue is another one.
All right. Any further discussion on this before we direct Rachel with this approach to the exercise? Sarah?
I was just going to ask that, do we need an official motion? And if so, I'm not sure what that needs to state.
I think we do, because we're not changing our budget as we submitted it, but we are doing this exercise, and the result of it could be that finance and management takes that and goes with it, and thereby, changes our budget, right, Rachel? So, Sarah?
Then I'd like to make a motion that we submit or apply by increasing our special fund revenue forecast to 1.54 million.
Okay, thank you. Alex?
I'll second that. I just wanted to have a little more discussion once we get to that point.
Yes, well, discussion on the motion that has been seconded?
Yeah, so do we not want to talk about the expense side at all at this point? I'm happy dealing with this exercise primarily through better revenue estimates based on our conversation, but we know where this is going. Eventually, the revenue will decline. So I don't know. I'm just curious if others want to talk about expense adjustments.
I think we have, as we all know, very little discretionary funding. And if we were to look for items to cut, we wouldn't get there unless we cut a person. And I don't think we have any interest in doing that. Sarah?
I don't.
Right.
I don't
Sarah?
either. And I think that just to speak to that crystal ball on the forecast is right now, I think we can speak to the current year that we're in and the projection for next year. We're going through a revamp and taking on new duties, and yep, there are going to be areas of exemption. And so the further out that we get, the better I think we're going to be able to forecast. So I think that, yes, I think to speak to at some point there is going to be a bit more potentially of a revenue cliff if more people take tier 1A. I think right now people don't know how to respond necessarily to it without the guidelines being finalized. So I think there's room for more accuracy the further we get out in terms of projections. And hopefully that will help give us a better sense in terms of what sort of program we're going to have and our long-term expenses and also our long-term income projections. So, but yeah, I'd second it is just we have very little discretionary funds, and we are mostly a people-based organization. And given all these needs that we're getting through and all this transition, I don't think that it's prudent to be talking about trying to deplete those resources as we're on a precipice to continue the change. Thanks.
Which isn't to mention that we value the staff that we have and we are, committed to keeping them on board. So
That
even our
your
newest
impression?
ones who are sitting in the room there yet to be introduced to us. So
So Rachel,
Any-
is it your impression that the Office of Finance is coming back to them with a revenue adjustment is what they meant? It conforms with what their request was for us?
It's one way of satisfying the request. It's not the only way. You could be cutting expenses, but I agree with Sarah and Janet that the amount of expenses we would need to cut would not be able to be accommodated solely within operating expenses. It would. So I think that what finance and management would like to see is a justification of why the revenue is adjusted, that there's a data-driven analysis that supports it. We've done that. We can explain it to them. And I do think that this is a satisfactory answer to the question that we received.
Great, thanks.
all right, any further discussion from anybody? All those in favor of the motion, please say aye. Aye.
Hi.
That is 5 ayes. That is unanimous. So Rachel, you have your direction
Thank you.
for the exercise. Okay. Pete, do we have more to discuss on legislative?
Yeah, I think it might be helpful. Do you mind if I do a quick introduction of our new employee and then
Oh,
we
I'm
can move
sorry.
on to that?
Yes,
Yeah,
this would be the perfect place to do that. Go ahead.
great. Yeah, you'll get to meet him on our staff meeting too, but it's Nathaniel Barham's first day here at the office. I am just ecstatic to have him here on our team for the district coordinator roving position that we worked on the hiring earlier this fall. He's got a wealth of good experience that's very relevant. He comes to us from the town of Charlotte as the town administrator, has worked in the New York State park system for a while prior to that. And we're just really happy to have him here. And this is our board you see on screen. You'll get a chance to meet them in person soon enough here, at the very least, at our annual meeting on the back end of the month here. So welcome, Nathaniel, and yeah, just excited to have you. If you wanted to say anything, you're welcome to just do that.
Well, thank you all thank you for the introduction. Really excited to be here, really excited to be a part of this organization, and looking forward to working with you all.
Thank you. Welcome, Nathaniel.
We'll probably keep him around for a little bit, but he's gonna jump up for continuation of his training here in a little bit too, so might pop down a little bit later.
Kirsten.
Do you go by Nathaniel or perhaps Nate? How do you prefer to be?
No preference either way, but Nate's totally fine.
Okay, thanks. Nice to meet you.
Nice to meet you.
All righty. Thanks for being here, Nate. Thanks for coming on board. It's a time of pretty big change for this program, so exciting time. All right, Pete, legislative.
Yeah, great. Thanks for the opportunity. I know the board is aware of the various proposals that you had collected as sort of your priorities, and I wanted to touch base on that with you all. One, to see if I've captured everything. If there's anything else that you wanted to mention onto that list, I'm happy to take that. And then just focus us in a little bit on kind of next steps. We're going to need to take some of this and draft some language based on some of these priority items as well. And I want to be able to work with the legal team on that and give them direction kind of in terms of moving some of this forward. So there's that aspect as well. And then we will be looking for sponsorship from the legislature as well to move some of these items forward. But
Pete, can you put on screen what you last shared with us, the sort of reorganized sheet?
Yeah.
And I did not get a chance to look at that before today's meeting, but I wonder if it included our discussion as a board about the enforcement question for Tier 1A.
yes, I put on
Okay.
a placeholder based on the board's discussion on that. And
Okay.
you will see that here in a moment's notice. Never like doing this working off of one screen. It's always a little more challenging, but let me get there here a second.
I think it's the last item on the list, actually highlighted.
Pete, I'm happy to share my screen if you'd prefer that, so it's easier for you to work with the document.
That would be great if you've got it up, Alex.
Yep. Coming right up.
Almost there, but I will, let you take the reins if you don't mind. Thank you.
Believe this is the correct document, but it's shared, so you tell me if I'm not.
That looks good. Yeah, can you scroll down to the bottom?
Yes, I can.
Yeah, so you can see that last highlighted item. That's the one I think Janet was
Okay.
mentioning.
Yep.
Yeah.
Okay. Thanks.
Yeah,
I
so
just
that's
wanted
the
to be
right one.
sure it got added.
Yeah, and so I guess if there's any discussion on that piece, we could start there.
I think that captures it. And, maybe we just need Jenny and Rebecca to look it over as well, if they haven't yet. Sarah, you have your hand up.
So are we proposing a fix to it? Because I'm trying to figure out which. Are we?
This is, I think, a policy
Would call it a policy shift, yeah,
shift or
but it,
clarification, depending on whether you put stock in the interpretation that this is what they meant by the existing language. Some of us see this as a policy shift, and it's clear what is meant by this.
All right, maybe it should be only as opposed to any.
Where is that, Sarah?
The appropriate
any
municipal
existing
panel
permits?
shall enforce
Only
municipal
existing permits. Where, I'm sorry, are you reading the proposed language?
Yes.
And so you're saying within a Tier 1A area, the appropriate municipal panel shall not enforce any existing or only existing permits? Is that where you're
The
saying
underlying
change it?
language I understand is the proposed language.
Yeah,
And maybe it should be, it reads right now, the appropriate municipal panel shall enforce any. Maybe that should
okay,
be the
only.
appropriate municipality shall enforce only municipal permits issued.
Yeah,
pursuant
got
to.
it. The second any in the sentence. I would agree with that change. Brooke. Or second second in that paragraph. Brooke.
Yeah, I agree with proposing this language change, but I don't want to fast forward beyond originally we were trying to determine what the correct legal interpretation of it is.
Yeah.
And so this is assuming H is operative and it's the first
Yep.
interpretation, and which I think is correct. But I do think that this is a very beneficial change that could relieve the tier 1A concerns of some of the municipalities that we have heard are concerned about that aspect. But but are we all on board with interpretation 1 as being the correct one? And that's why we're proposing this?
I think the board was, yes. Maybe Kirsten, do you have a response to that?
Yeah, I definitely interpret the existing statute to mean that within a tier 1 area, the municipality is responsible for enforcing all of the previously issued Act 250 permits that are in effect within that tier 1A area land, and the ones that are otherwise transferred to the municipal permit by virtue of a permit amendment. So I'm myself very clear on that interpretation of the statute, and I do support the change that's contemplated here, and I like Sarah's rewording of the approach.
Thank you. Alex, do you have comments on this?
I like this wording and Sarah's suggestion. However, I think that we discussed that another section of statute prohibits permit amendments from the prohibits our program from exercising jurisdiction within tier 1A areas, regardless of whether permits have been transferred or not. So I think the legal challenge or the conundrum, but correct me if I'm wrong, is that even if we made this change, even if the legislature made the change that we're suggesting, there's still going to be a strange limbo land for tier 1A areas that have an Act 250 permit that needs to be enforced by us. But as part of the enforcement, we can't compel them to come for a permit amendment. All we can do is presumably tell them that they're in violation and maybe seek a fine or something like that to come into compliance, but we can't compel them to update the permit. I guess we would be saying, go to your municipality and do it that way. Which I guess is not the end of the world. You can tell I'm thinking through this on the fly, but that was the sort of conundrum that I was stuck in. So if we're all comfortable with that, then I guess this all makes sense to me.
Yeah, I'm comfortable with that. Sarah?
I think Alex just answered his own question, so I don't need to, but I was just Alex answered it better than I could have, so.
Hey, Brooke.
Yeah, I was kind of thinking along the same lines. You got my wheels turning, and so just to walk through it to make sure that I'm on board in the right place. If they're going to change an existing Act 250 permitted project, they don't have to come to us to change anything. They have to go, if they need to under local zoning, they have to get an amended permit. And the conditions of that original permit exist, but can they be changed by the municipality? Like, let's say it has a condition that the amendment is going to significantly change or can't be complied with because of the amended permit. My only conundrum is when they do that, they have the obligation of pulling over the conditions from Act 250 that are still operative but haven't been covered in the base permit.
Yeah.
But so they have jurisdiction basically to change existing permit obligations of Act 250, right? But only to the standard.
They are the only ones that have that
Right.
authority. We lose it. We don't have that authority anymore in tier 1A areas.
Right,
in
and
ess-
that's
so in essence-
4461G. And
Right.
once they've transferred the permit, they have to notify the board of their transferred permit. So in our
So-
capacity as, the sort of overseer of the Tier 1A status, that's information that we have in terms of how they're doing. And I think that's where our oversight is in that sense.
So the municipality, is this correct? The municipality could just negate a condition of the Act 250 permit with an amended zoning permit because it conflicts. The project now conflicts with an old condition?
So they can only negate it under the, at least legitimately under 4461G. It has to be for, it has to meet one of the four, is it 4 or 5? I can't remember right now off the top of my head, but instances that would allow for that. And if they can't, if their regulations do not address the condition, the pre-existing condition, or the project, or it's no longer relevant for other reasons, they must transfer that. And if when they notify us, we see that they did not transfer something that they should have, that's information for us as the overseer of their Tier 1A status.
Gotcha.
So that's where I see our authority sort of lying, and that is, are they adequately interpreting statute when they transfer a permit?
Gotcha. And I'm in favor of the language that Sarah said, not what was written, but the other version, I think is a better way to say it instead of sort of like a double negative. I don't remember the exact.
Appreciate that. I'll just note too on any of the language that's there, that's kind of first blush language to give you an idea of potential ways to fix these things. We'll want to go through and make sure we've got things in a way that really meets the intent of the board in terms of the legislative fixes here. But so yeah, first step, but I appreciate that language suggestion there. And
Right,
to
and
Alex's
as I-
point on, the Title 10 piece there, 6081, that's an area where we may want to look at that language with respect to the change that is proposed in Title 24. And got that down there as
Right.
another potential area to make some change.
Is that in this list, Pete?
Yeah, I've got
It
it
is? Oh, where?
there on the references.
Where?
On that last, the topic we were just talking about, I have 6081 as one of the other potential
Oh, I see.
areas of
So-
change under the references, yeah.
However, I think that what we said was we're comfortable with not going there right now. So I don't know that that
Yeah.
should be part of this list. Jenny?
Just wanted, throw my 2 cents in and say I totally agree with the discussion that's happened so far about the relationship between how the permit conditions would transfer over or not, and where your authority comes in to review the town's use of that. So I'm really glad. I think we're all on the same page. The discussion about 10 VSA 6081, I think there's a little bit of nuance there in that there's enforcement authority can include things like requiring permits and permit amendments. I think 6081 takes that off the table in Tier 1A areas, but there are other enforcement issues or concerns or mechanisms that would still be available other than that, than simply requiring permit amendments or
Right.
or new permits. So just
Right.
to get that little narrow exemption in there.
Right, and what I was gonna say again is that we do want you and Rebecca to look at the language that we would be proposing
Absolutely.
before proposing it. So, any further discussion on this? We're a little bit over time, so I kind of want to move on if we can. Sounds like we can move on. So Alex, I think you can, Kirsten,
Well, can I just ask, is there another entity that we're aware of that is looking to address this so that we wouldn't be leading on this as a policy topic?
not
You can
this,
certainly,
From
yeah.
not
the
this,
LCT or,
no, not this year. I don't think. We have not heard that the RPCs are not going to address any Title 10 revisions or fixes or changes in this second half of the biennium. And I don't know about VLCT. I guess we could reach out and ask, but I have not heard that anybody else is working on proposing this. Brooke,
It would be nice if we had the Vermont League with us, but this is an important policy and operational issue that also appears to be a snag in people embracing Tier 1A. I think this is right in our lap to make the proposal. And I think we should do so even if we don't get anyone else on board with it. They have so many other priorities right now.
yeah.
This is
And
important.
I think that certainly VLCT and the RPCs or VAPTA would be supportive of this too, but the RPCs, as I said, are not pursuing any Title 10 changes. Okay, to move on? Okay, Alex, you can stop sharing. So while we were otherwise occupied last week in Rutland, Chittenden County Regional Commission submitted a pre-application to the board. And we have the task today to designate one of us to coordinate that review. And I would like to put Sarah forth as that coordinator of the pre-application review for the Chittenden County Regional Plan.
That's a motion. I'll second it.
Is it okay if the chair makes a motion? Everybody okay with that? Okay,
Yes.
then yes, thank you, Alex. Any discussion on that?
is Sarah
Here's some-
agreeable to take on this big regional
I
plan?
Thank you. Although I would always welcome help.
We will be there for you, Sarah. Any further discussion on that motion? Taylor or Kate, any thoughts about Sarah coordinating the review of the Chittenden County Regional Plan pre-application?
I think it sounds wonderful, and we've done our best to make it very straightforward for Sarah. So,
Great. Thank you.
So,
All right, let's take a vote. All those in favor of the motion, please say aye. Aye.
Aye.
Hi,
I'll abstain just for
Oh,
purposes, but thank you.
all right. That is 4 of us then, and that motion passes. Kirsten,
so this is a little after the fact, but just to confirm and clarify that staff have advised us that that application, pre-application is complete, correct?
yeah,
Thank you.
And while you're looking that up, Janet, I'll just also disclose that within my previous employers, I was employed within a Chittenden County municipality. But that was more than 4 years ago. And under American Institute of Certified Planners, there's a period where they recommend that you don't judge past employers, and I'm clearly out of that window now. So, but I'm happy to disclose more, but just I take the opportunity to disclose that.
Okay, thanks. Okay. Sorry. I was looking at the database.
While you're
Here,
looking, Janet, Kirsten, I would just say that it would be nice to know whether that pre-application has been deemed complete by staff, but the point, designating someone to shepherd the application, the
it can
pre-application.
be separate. Yeah.
We want to select that person today anyways, even if there's some minor tidy up that needs to
Oh.
happen to make the pre-application complete.
Sure, I just wanted to confirm that's the status as we understand it.
Yeah, this is Maddie. The application, pre-application is administratively complete.
Yeah, and I'm looking at the list of materials and it looks complete to me too. So, and we did clarify on screen last week at our meeting in Rutland that the future land use map information is on our viewer. So, yeah. Okay, moving on. Studies and reports. We're briefly going to address accessory on-farm businesses and our work in that respect by Taylor and Kate. And then we'll move on to a substantive discussion of the appeal study, the draft appeal study. Kirsten, are you going to head up the AOFB discussion or report or update?
Sure.
Whatever you
So
want to call it.
this is just kind of a general kickoff, and Sarah, feel free to jump in here, but maybe just for general orientation, I'll show everyone the statutory language to just remind everyone. So this is the Act 181 language about Tier 2, the Tier 2 report that is due February 15th. And in particular, the accessory on-farm business component, which some people call, AOFB. So we are to report on review whether and how Act 250 jurisdiction over commercial activities on farms should be revised, including accessory on-farm businesses. So this is due mid-February. And I've, researched some of there's been a lot of discussion of this, and I've researched some of the historical documents, but I certainly don't pretend to have the whole picture. And I think when Sarah and I spoke, because we're working on this together, we had envisioned at least initiating getting something down in writing as an in-house activity, working with staff and the board, and then inviting other, participation and leveraging the existing working groups and stakeholder groups. So I'm not at a point of having like a document to share. And there's no statutory requirement to have, a working group dedicated to this particular topic. But we certainly recognize that there's been a lot of interest, and it's on a pretty short timeline now to get this done by mid-February.
Yeah. And I'll just add that that although we have asked the chairs, thus far we've spoken with the chairs of the legislative committees of jurisdiction, and they have suggested that they're amenable to our request for an extension on the general Tier 2 report to September 30th, 2026. However, the ag committees in particular were interested in getting this aspect of the report on still by February 15th. So I felt that was something we could do, Kirsten and Sarah, as the leads on that also agreed that it was possible to do. So that's why we're looking at just that particular aspect of the Tier 2 report for February 15th. We are still expected to present to the legislative chairs of the House. I always get it confused as to which is environment and which is natural resources, House, Senate. But that committee and House General and Senate, which is the Senate one, Pete. But those 4 committees of jurisdiction.
Agriculture.
It's agriculture and natural
No, the
resources.
ag,
Natural resources.
Energy.
No, it's so we have 4
Senate Natural and House
Senate-
Environment.
Senate Natural, House Environment, but what about the equivalent for the Senate for the House, Housing in general? Economic Development?
Yep, housing in general.
Yeah.
Affairs.
I think
Yeah.
they're
So-
lumped in, yeah.
Right, so those 4 committees still want to hear from us at the beginning of the session. The 2 ag committees are fine as long as we agree to give them the AOFB by February 15th. But we are expected to present our request for an extension on the rest to the other 4 committees of jurisdiction. So they're amenable to our request, but they haven't yet granted it.
I think we should probably plan, just as a matter of course, we should probably plan on a intro to all of those committees, regardless, just in terms of status of where we are and how we're doing and that type of thing.
Yeah. So January, we can be expected up on the hill. Alex,
Kristen and Sarah, our leaders on this, I would encourage you to get on one of our agendas soon regarding the question of weather in the statutory mandate. How is really interesting, and we could go all sorts of different ways, and frankly, this has been talked about in just about every legislative biennium over the last 6 to 8 years. So there's no lack of conversation on how, but whether is a different question. And I would appreciate at a board level having a little bit of a conversation about whether there should be any changes, given that there have been changes. Not only has there been discussion at all of the last bienniums, but the legislature has enacted incremental sort of changes to the statute with regard to accessory on-farm businesses in particular. So I'm not talking about short-circuiting, what you hope to do, but I do think there's a point at which it makes sense for an agency to respond to a legislative request for review and tell them, here's what's already been discussed, and there may not be a need for us to reinvent these wheels, or to even frankly try to bring all the wheels together in the same bike rack and throw the bike rack at them. It may be as simple as referring to the past conversations and legislative initiatives. But that's a conversation about whether in that piece of the statute.
so Alex, to sort of piggyback on that, I think we have heard from staff, from enforcement staff and coordinators, that the current rubric for determining whether an accessory on-farm business is jurisdictional is cumbersome, confusing. There is probably a need from our programmatic standpoint for some change. So partly what I was going to suggest earlier is that Jenny's team probably has some notes and some research on the topic that should be shared with Kirsten and Sarah. And Pete, I'm not sure if the coordinators also have maybe nothing written, but I think it would be important for Kirsten and Sarah to speak with the coordinators on this early on as well.
Yeah, I'd agree with that, and we can certainly make that happen.
Yeah, that's what I was, when I was talking about developing something internally, whatever information any staff, including legal, would have to, for the board to consider as in making some kind of initial decision about where we might go with this, and then reaching out beyond ourselves.
So I'd like to give Brooke her hour on the appeals if there's no further discussion on this topic right now. Is there anything pressing on this, or can we move on to appeals? Brooke?
We can move on to appeals, Janet, but I have not had any time since our last meeting to work on the appeals report. I do have, want to talk about the resources needed after Kirsten and I touched base with Rachel, but I don't need a whole hour, I don't think.
Okay. Okay, so I don't want to push away any comments on AOFB at this point, if there are any further. Sarah?
So just to ask the question, I think what Alex brought up was to have a board discussion about whether or not, and I think what the sort of counter to it was there's plenty of evidence saying that we should. Should we have a quick conversation as a board right now as to the weather question? Should we schedule that for a future meeting?
I think we should schedule it because I think we should have information from the coordinators and from enforcement and legal to inform that discussion. Alex?
I agree. I think that'd be wise. I, for one, would appreciate knowing just how many accessory on-farm business jurisdictional opinions have been rendered, because my sense of it is that I'm really intrigued by the farm cafe piece of this, which I don't think meets the accessory on-farm business definition, and I don't think that's the section of jurisdiction where that sort of comes in, but I could be wrong. So yeah, I agree, Janet. It makes sense to schedule it in my mind, and then just have a little bit of data for sure.
Yeah, Kirsten?
So Alex, thanks. That's helpful to know that particular information is of interest, and I'll do a little research. But I agree, I'm not ready to have the conversation yet. I think we need to have more information put in front of the board before we would have the weather conversation. And the other thing that I think is important to note is that there were already some pretty recent changes. And so we don't have the benefit of that implementation much, right? So there's that.
So Pete, I'm hoping you can help Kirsten and Sarah coordinate a conversation with coordinators very soon.
Yeah.
And Jenny, we had talked, I don't know, maybe even a couple months ago about legal getting some information put together on this topic. Are you still able to do that in a way that we can discuss it as a board somewhat soon?
Yes. Yeah, we're putting together sort of a list of the enforcement side cases. I'll note that there may be district commission, there may be JOs that we're not aware of, and there may be enforcement cases that the districts are not aware of. So this is going to be a really great opportunity for all of us to come together to get a full picture of what these things look like in front of our organization.
Great, thanks.
But yeah, we're looking to have something for you guys this week.
Oh, okay, great. Thank you. Sarah and Kirsten, do you feel like you need anything else before we move on to appeals here?
No, just look forward to connecting with Jenny. So thanks for letting me know you've already been working on this.
Okay. Brooke, given that you were under the weather and otherwise occupied in the last week, maybe we can just take some comments or suggestions from board members into account today, understanding that you haven't made major revisions since our last conversation. Is that okay? Do you want to frame the discussion at all first?
Yeah, and I have received comments from Alex and from you. I just haven't had a chance to go through those. There are some themes that, we've even mentioned in our last meeting. And where we left off was trying to make sure that we were going to be able to convey actionable recommendations. And so we have put more thought into and tried to talk through and analyze more information about the resources that are going to be needed so that we can, with some definition, even though there are a bunch of unknowns, we would be able to say 3 years, check in at 2, here's what we need for Act 250. Beyond that, we really don't know. We may need another lawyer, that kind of thing. So let me just share the cost estimates that we did have, and then after we go over this one issue that I really want to talk about, then we can take whatever comments that anyone has about it. But in trying to determine, could we do Act 250 appeals with our current resources? And there are 2 resources we need to think about. One are the personnel and one are the infrastructure costs. We talked about the notion of using our existing Act 250 database for the collection of pleadings, for an appellate case, that kind of thing. And there will be additional volume costs to house that information, but it also would not give us a strict firewall between systems. There were several issues that Rachel brought up and convinced me that trying to somehow retool the existing Act 250 database was not a good idea. Internally, externally, it's not as workable, and she can jump in if anyone has any questions about this. But I think the upshot is we're not going to be able to avoid the upfront infrastructure one-time costs, which, we have those one-time expenses depending on, here we were proposing 1 lawyer, 1 tech. Here we were proposing 2 and 2. The infrastructure costs don't change tremendously between the 2 situations, but we must keep in mind that we will have annual cost increases. If you look at the annual expenses, we have the 2 personnel listed, but then we do have, the maintaining the database, space charges for housing the data, as well as incidental costs, which I never even contemplated and, is required in order to get the system up and running. So in really analyzing timelines, existing personnel, legal, tech, etc., I have come to the conclusion, particularly relying on Rachel's advice and wisdom, is that we need to have a tech person if we're going to take on Act 250. There's a huge difference between filing a couple filings or keeping track of filings and storing them versus being an actual docket clerk, somebody that is handling the legal filings. And also the piece and part of it that we also will need is the administrative clerk type help. While a board member can certainly be the hearing officer kind of person for moving the litigation. There are administrative tasks, contacting parties, et cetera, when filings aren't done on time, just the administrative work of moving the case along that I don't think we can get away from. I think that we need another person. I think that we are asking a huge amount of our staff as it is in that regard, and I do not see any significant time that could be repurposed or reallocated to this position. Maddie is quite busy normally, plus she has had quite a few of additional job responsibilities. And while some small portion of her job may be alleviated, she will still have to do that same job for enforcement. So I think that we need to make sure that if we say we can take on Act 250, that we're capable of doing it. And I don't see how we get away from having an additional technical / clerk person.
And I think the rest of the board agrees with you there, Brooke. And I think the question is whether we agree that we need another lawyer, or two, or let alone two. So, I don't think that is that true, Sarah and Kirsten? Do you agree that, at the least we would need a legal tech? Sarah?
Agreed.
Kirsten?
Agree.
Yeah.
So
Yeah.
let me talk about the lawyer piece. This is very difficult to figure out because of all the unknowns. And there's one piece of information though that might be helpful in guiding us in this decision to get at least some handle on, one of the unknowns is what's going to happen with regional plans, the tier work. Would there be litigation arising from any of that? And the question really is, well, what potential litigation could arise and where? Would it be pursuant to, within Act 181? Would it be government action that's appealable to the court system under Civil Rules 74, 75? And so those answers I haven't even looked at, and I don't know if that's a piece of information that might be useful. I haven't even had a chance to talk to Jenny about this. We thought about it this morning when I was talking with Rachel. Is that something that, Jenny, that you might be able to help figure out? And I know you are doing a million things right now, but I'm trying to look for any kind of data point or information that we can attach to predict what's going to happen and if it's going to impact our legal staff. Are we going to be a named defendant in civil court? I just haven't even looked at what one would do if, for example, they were unhappy with a demarcation of tier 3 on their property, or something of that nature. So that's one of the unknowns. What's going to happen with litigation? So if there's any way to nail that down or to look at it, maybe we should. I don't think it's a showstopper one way or the other. And then, of course, the other issue is the repurposing of our staff. And I think that really depends on the need to produce a legal product that is equivalent to the environmental division from the legal perspective. We can add value to the implementation of policy, the drafting of conditions, but we have to also meet on a par with, have the legal credibility, which our legal staff can provide. And so it really comes down to, can we justify another lawyer? And do we ask for it? Do we say we can do it if, or we can try to do it without? But I am concerned about ending up in a spot where we don't have enough personnel to pull the job off.
So I think that we should have more, or you should have more conversation with Jenny on this. And I don't know, Jenny, whether you think that you feel that there is anything here that should be, that you would want to address the board in executive session on, or whether you feel that would not be necessary.
I'd rather discuss with the board in executive session if that's okay.
Okay, yeah.
Thanks.
So yeah, those are the issues, you know. What happens if somebody sues over tier 3 being on their property? What happens if others don't like that, you know, their municipality got tier 1A and their property wasn't in it or something like that? I don't know. So it would be helpful to sort of posit what those potential what potential litigation might arise and what the probabilities we think there might be for each of those. And then, yes, discuss it with our legal counsel, Kirsten.
Well, yeah, and if there's a way to ascertain if those kinds of lawsuits would be the ones that the Attorney General's office would provide legal services for,
Mhm.
or if it would be our program attorneys who would be doing that.
Right. That's a good point. Huh. The other thing that's related to this is its capacity and timing, Brooke. And I think that it is absolutely clear to me, maybe not to Alex, that given the load that we have through the end of next year, in terms of mostly, well, maybe not mostly, but the tier 2 reporting, finishing off the 8C and the tier 3, finishing off tier 1A guidance, and then taking in tier 1A applications for the first time mid-year perhaps, but also taking in all 11 regional planning commission applications, final applications for the plans, that there's no way we have the capacity for this next year. So the question is, when would we have capacity? Aside from what litigation might come up after December 31st, 2026. And I think that it would be important to identify the dates rather than just saying 3 years out, 2 years out. I think, you know, are we talking January 1st, 2028? Are we talking a check-in at July 1st, 2027? I think we should say what those dates are rather than 3 years out, 2 years out. So
I do agree, and I have thought more and more and talked within our program about transition time, rulemaking, and we need to get the rules made if we're going to be the appellate body and then get it through the rulemaking process. So I see the preparation of the rules with all of our other work right now and the other rules that have to be incorporated into that rulemaking. I'm looking at a year for that and then a year to get it actually through the LCAR process. And then we need transition time to build the database and transition to taking the appeals while the existing appeals of Act 250 get completed at the court. So there's going to be court cases concluding while we're taking off on the new jet, if the legislature decided to do this at all. So that's where I'm coming from on the 3 years. I don't think it's realistic to shorten that time frame in order to do this right and professionally and have it set to go with a turnkey operation.
Just thinking about, for instance, tier 3. So we started stakeholder meetings, what, in February, Alex?
April, the end of April.
April. And we're expected to submit to Alcar in September. So that's a little over a year to get it to Alcar, and then through the Alcar process would be by December. So it's a year and a half, right? Maybe not 2 years.
Yeah, but we're not going to know what the legislature decides to do until months from now.
Right.
You know.
Right. So if we knew by the end of this biennium that, oh yeah, we're gonna have you take on appeals at some point, we would start that work in July 2026 and could be finished with it in December of 2027. So 2028 could be January 2028 could happen.
Well, we got to get the plane built to take off too.
I don't know. We're building the plane as we fly it now. Isn't that what happens? So I don't know. What do others think? Alex, come on. What do you think?
What do you mean? Come on, I already
Well,
stated my
because you're the
piece.
one who says that we can do this quicker.
Yes, well, my quicker is not not that dissimilar from what you just laid out. So
Okay.
my date is I will backpedal a little bit and say instead of July 1, 2027, my date is December 31st, 2027. I think we can
Okay.
I think we can have our rules in place and take it over and begin processing appeals by that date, end of 2027.
Okay. Kirsten?
I think Brooke's schedule is realistic.
So what is that for a take on appeals date for you?
I guess it would be more like January 1, 2028.
That's what I just,
Like
that's what Alex and I are saying.
Oh, okay.
So do
And
you mean
that's-
2029?
No, 28.
Okay.
I mean, I guess Brooke, back up a little bit. When you
Right. So
what
yeah,
am I
let me-
missing?
So if, let's say by July of 26, we're told it's a go, you're going to take Act 250 appeals. So let's just say from July, we need like 9 months for the rulemaking. We got to create the rule to begin with. So that is like a year and a half. So at that point, have we already built the database and all that so that we can go live as soon as the rule gets made, or will there be then time that we have to spend doing it at that point? I guess it depends on when they give us the money,
Yeah.
Well,
right?
Yeah.
So that gets us a year and a half out. And that's where we're getting the December 31st, 2027. I think it would make more, well, January 1st is a great date to start something, but it sounds a little tight.
So I think that part of our recommendation should be that if they do give this to us, that we need that $100 and whatever $1,000 to set up the digital database infrastructure up front, not
Right.
later. So
They can be constructing that while we're constructing and getting the rules passed.
yeah.
Yeah, that can both happen at the same time. And the
Sarah?
rules for the appeals,
Oh.
that's not that big a ask. It's just, how does that work with the other rulemaking that we're doing? Do we fold it into that? Or do we have to do a standalone change to it after that's done? It's not, but it's not a huge deal to create the rules. I already have them drafted. They just need to be fine tuned. But it's the 9 months getting through LCAR process.
That was
Sarah, can we hear from you on this?
So I absolutely am on board with everything that Brooke just said, and I don't know if Brooks settled on a date. It sounded a little bit, I agree with it. It would be nice to know when we're getting the money and then plan out from there, but do you think we're looking at, as opposed to a January, a July?
That would make me feel more comfortable. And
So I'll
January
just-
is always a tough time to implement something, right? Because you're coming through the holidays. Sounds like a
July's
great
the-
date to start something on January 1st, but
Start of a fiscal year too, so why don't I pick, sorry, Alex, we're getting away from your December, but I think July, good things are worth waiting for.
July 1st, 2028.
I think that is
that's a
also,
good one.
I
that's
think
good.
So
we
that's
were
less than 3 years.
talking 2029, I was gonna say it's sort of splits the difference.
We want Alex to know we've been listening to him.
A date that people are comfortable with, July 1st, 2028. Kirsten?
Yeah, I was gonna say, I think we're so busy through the end of 2026. I don't really have a clear understanding of how much work needs to be done for the rulemaking, but Brooke, you just described that you think it's sort of almost ready, something has been drafted and almost ready to go in the oven. Like I just don't know what other kind of process or work or board work needs to occur as part of that. But giving us more time so that we're not having to somehow carve out board resources and staff resources to get this done in 2026 would be would seem pretty ambitious to get traction on it in 2026. But that's just
Well,
my,
I think we're not talking about 2026. We're talking about
well, no, but
2027.
well, right, but doing all that lead-in work to the long rulemaking process.
In 2027,
Right.
not 2026. Yeah, that's what we're talking about. So somebody at 10 Baldwin. Pete,
Yeah, just a quick thought. I know you guys are negotiating and trying to balance a number of things there, but one thing I'll say with ending at the sort of the start of the fiscal year is also sort of the end of the legislative season. So you really only have a month or so before the end of the legislative session for any changes that might have occurred during that last session to then implement with that. And it might be helpful to have something like a September operational deadline, something like that. Just throwing that out there.
though I think we would be expecting the direction from the legislature to come. This is if it comes in 2026. Oh, wait, I'm sorry. No, 2027. So we're talking about legislative direction 2027, implement 2028. A
Yeah.
year later.
Well,
And then there could be, I guess my point is that there could be then legislative, they implemented the year before, right, through the legislation, and then you have another legislative cycle where there could be changes on how that implementation occurs. maybe there wouldn't be, but there could be, in which case kind of unhinging it from the legislative cycle might be helpful to give you just a
So,
little bit more time for
in-
implementation.
In
Maybe
which
I'm
case,
yeah.
in which case, the legislature should give us that time. So, we can, maybe that can be a caveat somewhere, but, we can do it. We can say that we can implement July 1, 2028, unless the legislature throws a wrench in it in that session directly beforehand. And if so, then please give us more time.
Yeah,
So-
and you can always advocate for it at that point too, for
Yeah.
additional time if you need it based
Yeah.
on changes that were made, but yeah.
Kirsten,
I don't understand how we would be able to implement in 28 based on legislative direction in 27 unless we started the rulemaking in advance of legislative direction. Is that what's contemplated? Because it seems to me, why bother with the rulemaking if the legislature hasn't even defined that direction? And that we would be
Well, it
seeking
sounds like-
legislative direction in 26, part of the current session.
Brooke is telling us she has that drafted as part of this appeals work. Is that not the case, Brooke?
Yeah, I mean, it's not gonna be a construction job from, nothing. I've
Right.
used the old e-board rules and, infused some PUC stuff. So, I mean, sure, we have to go through the rulemaking process, but it's not gonna be months of writing the appeals rules. It's going to be a much shorter process. We'll have legal look them over as opposed to just me create them out of whole cloth. But, they're not, I mean, we have so well defined how we want it to operate. I'm not worried about creating the rules. We just know we have a certain amount of time that we have to, waiting times, notice, you have to get through that process. So now, if they tell us this legislative season, yes, it's a go, then we have time to start implementing and presumably they would give us the money to start building the ship or the airplane. Now, if they don't do anything and they decide to wait a whole year, I think that's a whole new ball of wax because then we're in a different situation. Not that we can't do it, but if we haven't done the legwork to make it all, prepared to happen, then we may be delayed a year, or maybe not quite that much, but you know what I'm saying?
Yeah.
Well, yeah, and I would think the LCAR, I mean, I would envision that they wouldn't be looking to see and recognize rules that aren't backed by legislation, right? Like, it,
Right.
yeah. So
We wouldn't be
I
submitting to LCAR
agree.
if
Right,
if
so I
the
agree
legislature didn't
wholeheartedly
give
with what
us
Brooke just
the-
said.
Yes.
If something doesn't take effect in 26, then we'll have to revisit all of this.
At least from a scheduling perspective, sure.
Right.
And, at that point, we may have more information like when we're proposing for the check-in. So let's talk about the check-in date. If we're targeting July of 28, we want to check in with them at a point in time that matters to them. I mean, just doing it in July of 27 doesn't help anybody because they've just finished their work. So I think we got to back
January
it up,
27.
right?
Hmm.
So it'll be check-in in January or the prior November or what date would you all like to report in? If
Say
they want
November
us to.
2026.
Okay. Which is a year from now. Well,
Yeah.
whatever information we have, we will incorporate and tell them where we're at. Sound
So,
okay? That's a little sooner than I wanted, but I don't think we have a choice if we have to be cognizant of their deadlines and when they can act, so.
So, this is your Appendix D, Proposed Board Rules of Appellate Procedure. So you're going to be including those in what we submit next month, correct?
Yeah,
Okay.
it's just 2 rules. Yeah, there will be a few other changes within the body of the rules. There just maybe I picked up 2 other just minor wording changes that would need to happen if you infuse these in. But yeah, it's literally 2 appellate rules standalone that could be easily incorporated, even with the same rule numbers that used to exist with the old e-board rules. It's 40 and 41, I think. My memory serves me.
Okay.
So yeah, I will have that hopefully by Thursday, but if not, we'll look at them in the coming week, the next 2 board meetings.
So, our meeting is Wednesday, right? Wait, Thursday, right?
Thursday,
Yeah,
23rd.
in Randolph. Okay, and so if we're having the first public meeting this Thursday, should we not have those appendices already appended? Or do you feel like it's okay to hold the hearing before the appendices are finalized or not finalized, but drafted?
Yeah, I mean, it's just a timing issue. We just couldn't get it done in time. But I don't know that we really need to be wordsmithing rules, because here's the thing. This is going to be an appendix. It's not going to be run by legal. It's, this is the basic notion. The chart explains what the standards are and how we're going to operate. We'll narrative that. But it's going to be, here's a proposed model. We got to work on it if this is actually going to happen. But spending the resources we don't have right now with
Right, yeah.
legal to, we just can't
finalize.
do it.
Right,
It
right.
just, and we don't even know that they're going to do it.
right.
So
Okay. Kirsten,
So Brooke, will those appendices be marked draft?
yeah, everything has a draft watermark on it. Yeah. But I mean, if I can get them prepared by Thursday, much more important is the report itself. The rules can be put in at the last minute, really. That is not going to be the centerpiece of this. It's going to demonstrate we can do this. Here are some draft rules. We'll work on them if you decide you want to do this.
so any other comments for Brooke on the draft appeals study from board members?
So then my plan is to incorporate Alex's changes, Janet's changes, see what else I can get completed on my own laundry list of narratives and better analyses. And what I'm planning on doing on Thursday is using a red line strikeout of the report with those corrections and changes, etc. Even though people will not necessarily have seen the red line strikeout version, that way we can move through some of those issues that people might say, hey, you need to work on this or whatever. And we'll say, yep, already got that. They're not going to be massive, huge changes that people aren't going to be able to pick up on. So,
I mean, most of my changes were pretty mechanistic, not substantive. The one question I have is, I think you said last week that you intended on sort of fleshing out the ombuds office idea somewhere. So that is something that you said you were going to work on, correct?
yep,
Okay.
for sure.
Okay.
Yeah, I don't want that to be the orphan of this report. We've been so focused on the mechanics of it. We need to make sure that we do address that and give the ideas to legislature that we have about it.
Alex?
So Brooke, you handle this however you think most appropriate for the public hearing on the 23rd. But my suggestion would be, let's not promulgate any other versions than what's already up on the website. Let's walk into that hearing with that version, no red line, anything, just that
Okay.
version. And we take public comments on that version. And if people ask us, did you guys talk about this yet? We say, yeah, and we've got some ideas for some additional changes, but this is the version we're taking comments on, and it'll just keep it cleaner.
Yeah.
Okay.
I agree.
Yeah, that's a better idea. You're right.
And
Kirsten,
And we're still taking RID comments, like you through like beyond this week's meeting date, right? Like once a revised version is perhaps made available, people would still have an opportunity to comment. Like what, how
for
do you
sure.
envision this will get to the finish line of the mid-November submittal date?
We're gonna take any kind of comments that anyone wants to offer. I'm not gonna cut it off on the 27th or anything. We'll take it through the final review of the board before the final review of the board when we vote on it. I'm not shutting anybody down, and when we get a new version, I'm going to distribute that to all the stakeholders, make sure that they see the changes, and we'll post draft number 2 up. Now, let me ask you all, is that, Alex, would you suggest doing a red line strikeout and then a new version, or just a new version if we're doing a different draft?
Yeah, see, this is why I don't like the red line strikeouts for the public. It'd be different if these were rules. You know, we'd have to have the actual verbatim version available to people to comment on. This is a report. I feel like we've published a version, and I don't feel any obligation to provide a revised version at a later date, assuming that we don't like shift by 180 degrees all of our recommendations. So I'm happy to get, this is just me, Brooke, but I'm happy to get public feedback on the version that's been published all the way through the comment period, and then make additional changes based on what people recommended and what the board discussion was, and then publish the final version. No additional bites at the apple, but that's just me.
I would agree with that. 10 Baldwin.
There's no longer a public comment.
Okay.
I like the approach, more simplified. Yeah. Because I mean, we're not necessarily asking for, give us a rewording of this sentence kind of thing, right? This is about ideas and proposals. So I'm fine with keeping that the only draft. I
Yeah,
mean,
for now,
that
and
we
then-
ask for a public comment on. I mean, anybody,
Right.
we can have it posted and anybody can comment at any point.
I mean, I think we should have a deadline for comments. I think it should be probably at least the Friday before the board meeting.
Okay.
And then the board finalizes, adopts a final version at that meeting.
Okay. That's a lot simpler.
thought-
I was thinking
thought we already
serial
had
drafts.
Yeah, I thought we already had a deadline for public comments, and it was a certain number of days after the public hearing.
Yeah, I
Yeah.
think we do. Is it 10
So-
days?
Yeah, well, and the 10 days
Or
is
less.
straddling, so I think it's, I think that we can extend it for another week. I mean, from what I had originally specified. So the 27th was the date, and what's the following Monday?
Let's see.
So if we did it to November 3rd, that's 2 weeks before it's due. I think that's
Okay,
plenty of time, and that'll give people 17 days. Well, it's been up longer than that even, but like 20 days.
okay.
I think that's good. More
Yeah.
than enough. Okay. Thank you, Alex and Janet, for straightening me out on that. You don't need serial versions
Oh,
and
I see,
confusion.
yeah. Yeah. Okay, are we any further comments on the draft appeals study from anyone?
So
Kirsten's got her hand up.
Oh, sorry, Kirsten, go ahead.
that's okay. So not at this time, but I completely agree with what you're saying about the serial versions. But I'm a little hung up on that we've got this placeholder in the draft report for draft board rules. Because I don't know if that would be seen as, a substantive component. Thank you for explaining, Brooke, that, the bigger context, and that would, I think, go in still as a draft, so that the legislature could say, yes, if this is to be implemented, then the rules get taken up and advanced and put into a more final version. But I just wonder if we should in fact be posting on the website and making available a version of this that includes the draft board rules of procedure.
Or it could just be a
Or
separate
perhaps do
posting.
that as a separate document.
Then you don't have
because
to have a new
I just
version.
don't want, yeah, it
Yeah,
just makes me a little,
Yeah, standalone, and this is going to be appendix, whatever the number is going to be or
yeah,
letter.
draft.
Okay, I can do that. Whoops. Not hearing you.
Oh, I'm
You're not-
sorry. I was just
nobody
saying,
said anything.
I think it'd be great if we were able to do that. So thank you.
Okay, let me try to get that out in time for the meeting, and
Oh,
we'll
I don't
certainly
think
take
it,
public comment for it, for the entire time as well.
I don't think it necessarily has to be done time for the public meeting, but just as long as it's available before the comment period sort of ends.
and
Yeah.
Okay. Yeah, that'll be good then to extend it for
I
another
mean,
week, 'cause that
ideally, if
way,
it's gonna, ideally, it would be good to have it before Thursday on
yeah, I'll try.
available. Okay,
I think that's doable.
okay.
I just have to pull the cake out of the oven and look at it because it's been a little while.
Stick the toothpick in,
The test
see how,
Okay, we'll get that out by Thursday.
okay. All right. Let's move on to the next agenda item. Do we have a motion to go into executive session?
Yes, I will move that we go into executive session to talk about appeal and enforcement matters, as well as personnel issues, and to have confidential conversations with our attorneys, with the understanding that discussion of these items could place the board at a substantial disadvantage.
Thank you, Alex. Good off the cuff. You got all the points we need.
I'll second.
Sarah, thank you. Any discussion on that motion? Okay, all those in favor, please say aye. Aye.
Aye.
I,
That is unanimous. We will go into executive session and report back out in this meeting when we are finished before adjourning. So see you soon. Sorry, my microphone was off. Sorry. Okay, we are returned to our open session. And I think there is only one thing left to do here.
I'll make a motion to adjourn.
Thank you,
Second.
Sarah.
Second. Oh, Brooke
Well,
got it.
Brooke got it. All right. All those in favor, please say aye. Aye.
Aye.
Aye.
I-
All right. Thank you, everybody. See you soon.
Thanks.